we are very happy to have so many people joining us. I saw our guest list, attendee list today, and there's a bunch of people that we know and a lot of people we don't know. So thank you so much for joining us. Um, we are both lawyers at the firm of Hinshaw and Culbertson, and we are putting on this webinar today with the Society of Claims Law Associates, which I don't know, for those of you who don't know about the SCLA, it's a wonderful organization. And they do so much for the insurance industry and so much for just continuing education and making sure that everybody in the insurance industry that uses their resources is up to date. And they're a part of the American Educational Institute, which really produces and puts out um, top notch and really, cutting edge, the best that you can get as far as self-study courses and other materials to make sure that people within the insurance industry are able to meet their continuing education credits. And that brings me to a very important point. This coming May, less than 2 months away, um, the SCLA and AEI are putting on their annual Claims Education Conference in New Orleans. And I will be speaking. It is an amazing time. I've been many times, and it is the best way possible to earn one's SCLA designations, as well as get all of your continuing education credits. There's a bunch of professionals from law firms and the insurance industry and vendors for the insurance industry. And it really is a great time. It is worth every penny. I would encourage anybody who's interested in looking into it and seeing if your company will sponsor it. For anybody that is the person who approves expenses, it's really worth it for any of your colleagues to go. It's worth every penny. So please, there is the early bird discount is still on, I think, through the end of this week. So please do go to the website, look into it. It's really a great time and a great, just a great way to get your credits. Because we are lawyers, we have a legal disclaimer that we have to start with, and just saying, obviously this is not legal advice, but there's no attorney-client relationship being formed with this. For those of you who are looking to get CE credits for adjusters, we've had this program pre-approved for Florida, Georgia, Louisiana, and Texas. So the only thing we need from you is that during the presentation today, we're going to have 3 polling questions. And you have to answer them. It's going to pop up in your Zoom. It's very easy to do. Even I can do it. So it's technology wise, it is not hard. So please answer the questions. It does not matter if you get them right or wrong, but you have to answer them so that the CEU Institute, who we get the credits through, can verify that you participated in the program. And that's all we need, though. 3 polling questions. You have to answer all of them and you'll get your hour of CEU credit. And that's you'll know that it's a polling question when this sign pops up. For those of you who are attorneys who are here today, we will be giving out a CEU or a CLE code during the presentation. So just be aware of that and listen for it. And we will then be issuing certificates to you for the hour of continuing education credit. And we've also been approved in several states, including Illinois, California, Texas, Florida. So, and it's on the invite as to what states we've already been pre-approved for 1 hour of CLE credit.
And with that, let me share our first CLE code, which is XL. X as in X-ray, L as in Lima. Thank you.
So, and again, I introduced both of us earlier, but April is a partner in our Fort Lauderdale office, and she actually started in Chicago with me, and I am, and she's also licensed in both Florida and Illinois. I split my time between our Los Angeles office and Chicago, and I'm licensed in Illinois, Indiana, and California. And the reason we thought this would be a great presentation and program today is we both try a fair number of cases. April actually tries far more than I do. And there's a different perspective from a trial attorney as to how a case is evaluated. It is not as formulaic a lot of times as one would hope. It's not entirely dependent on medical specials, past and future, or lost wages. There are a lot of other factors that come into play. Those factors are very important. There's no question about it. But there are other factors that come into play that, as trial attorneys, we see. And that a lot of times the insurance professionals they don't have the access to see it. They're not always in the courtroom with us during a trial, and they're not part of maybe picking the jury or part of the writing the jury instructions. So the goal here today is to help the insurance professionals understand how the other issues and the other aspects of evaluating a case, the ones that we see as defense attorneys. So and again, this is for evaluation for reserving purposes, for settlement purposes, and possible verdict purposes. So we're going to start out sort of at the very beginning of that, narrative of, sort of the negligence case, and then go through to, the end where we're talking about releases and mediation. But again, the goal is to make sure that everybody has an understanding of how we as defense attorneys see the best way to evaluate a claim using the traditional methods such as the medical specials, and those types of things, but also going into some of the other issues that really do impact the value of a case. So with that, I'm going to start out with just what is a personal injury case. The personal injury industry, and it is an industry, it's analyzed by Forbes and other organizations that look at the finances of different industries. It's huge, and it grows and grows every year. That's why for those of you who drive on interstates and they think, God, there seems to be more and more advertisements from plaintiffs' personal injury attorneys every year. You're right, there are. And the money that is involved is astonishing. And it's interesting too. This I didn't know until I was looking at the data, but the majority of the cases actually are from motor vehicle accidents. There's also a large number of medical malpractice and products liability. And obviously, a personal injury case, it comes to us because people are seeking money. They're seeking financial damages. These are interesting statistics. These are pre-COVID, though, and I know April's going to talk about how things have changed post-pandemic. But the statistics are that nationwide, and I'm not sure how they get these numbers, but the median award is $31,000. And that changes depending on, obviously the motor vehicle cases median award is a little bit less than, or is less than what would happen in a medical malpractice or a products liability case. But you see sort of the spread, and you see the even and the fact that the motor vehicle median award is much lower is sort of offset by the fact that there are so many more of them. So, again, this is a huge numbers we're talking about. So how do those numbers come to be? Where does a jury, if they're awarding over $700,000 in a products liability case, what is that number based on? And with that, I'll hand it over to April.
Thank you very much, David. So let's start with what is the basis of the damages. First, let's talk a little bit about economic or compensatory damages. Those are fairly easy to quantify, although they are likely to increase as the case continues. We'll discuss a little bit later how past medical expenses can vary based on what the jurisdiction allows you to board at trial, if there are liens, things like that. And we'll also talk to you a little bit more about how those damages are proven at trial. But for the most part, the economic damages are easier to quantify. The standard economic damages we have listed up here: past medical expenses, future medical expenses, past lost wages, and future lost wages are sometimes called future loss of earning capacity. You might also have incidental damages on a personal injury case. And we're not going to tell too many war stories today, but I will give you some examples so that it can bring context to what we're talking about. I have a matter, a slip and fall, where the plaintiff broke her ankle on vacation in Disney. Her family had to leave the trip early, which cost them fairly significant amount of money in order to change their flights. So those might be examples in a personal injury case of some incidental damages that the plaintiff or claimant is going to claim, in addition to the ones that we have listed here. Next slide. And then we have non-economic damages, also called general damages. Those can be a little trickier because they vary from case to case and from jurisdiction to jurisdiction. What we're typically talking about is pain and suffering. Some jurisdictions actually allow separate lines from pain and suffering for things like disability and disfigurement. So you'll just need to know your jurisdiction with respect to that. But those are less quantifiable and it can make them more difficult to calculate. And as David mentioned, it seems a little different coming out of the pandemic than it was pre-pandemic in terms of pain and suffering damages that we're seeing for verdicts. So we'll talk a little bit more about that later. Why are we doing this? All right, well, we want to evaluate these damages as soon as possible, of course, to set a reserve, but also to assess whether early settlement negotiation should be explored. In some jurisdictions, especially where liability is clear, the insurer owes a duty to evaluate for settlement as soon as possible. So you want to gather this information and start assessing these damages sooner rather than later so that you can determine whether or not you should be discussing early resolution. But let's talk about how we do that. We start with investigating the claim. What are the first things you want to do when you get a new claim? First, you want to know who's your claimant. Find out everything you can about your claimant. Social media searches as soon as possible are a great idea. You can often catch something on social media before the claimant's attorney has warned them to clean up their social media. I'll give you a little example of that. I was brought in pre-suit on a case that involved a young woman injured in a scooter accident. She broke her wrist. She was a young yoga instructor and claimed the injury would affect her ability to earn money. Well, we were brought on early in the case and pulled her social media history right away and found out that she had posted all over social media about how actually the injury and resulting surgery helped her yoga practice because she could hold a handstand longer. So when we brought that out at the pre-suit mediation, her attorney withdrew the wage claim. Often once they've hired an attorney, the attorney tells them to clean up their social media. So if you all can pull those social media reports right away, you might find some gold in there. If you have multiple claimants, look for connections between them on social media. If you've got an auto accident case with multiple drivers, sometimes you can find connections there and possibly spot some fraud early on in a case. So don't just look at social media reports in a vacuum. Look at them together.
And make sure you do save them too, that in whatever way you either like in a PDF file, because again, they're going to be gone. And sometimes it is hard to get them back. So what you're able to find early, save it, print it, save it as a PDF, whatever you can do, and keep notes of what you found.
Absolutely. They're going to clean up their social media as soon as someone tells them to. So save, save, save. Background searches on criminal history and court filings can also be helpful. Be careful not to hang your hat on them. You might find a claimant that looks terrible on paper, multiple arrests and traffic citations. Maybe those aren't admissible, or they might not have the effect you think they will on the jury. We'll talk a little bit about that more a little bit later when we're talking about how you evaluate the claimant. But go ahead and pull everything you can on the claimant, background, social media, criminal history, and have that information and save it, keep your notes and save everything that you find because it could disappear. All right, what's the documentation that we want to be looking for? It's important to gather as much documentation as you can. Again, earlier in the case, the better. If there's a police report, that's a great place to start. It may contain details regarding what was said by the parties at the scene, if there are any witnesses, was emergency medical services rendered at the scene. I would caution you not to make 100% liability determination based solely on a police report. In some states, my state of Florida in particular, neither the police report nor anything the officer says is admissible in the civil trial. It's a particular statute that covers it because they want people to be as honest as possible at the scene of an accident. So therefore, it's not admissible in the civil trial, but it still can contain some really valuable information. I would just say you don't hang your hat in terms of liability on it. And I would also suggest requesting more than just the police report. More and more, we are now seeing officers with body camera footage, or there could even be a separate agency within the police department that did a more detailed investigation with measurements and photographs, depending on the severity of the accident. You can do a Freedom of Information Act to request that from the police department for their entire file. You don't need a lawsuit to have been filed or a subpoena. You can just send a letter pursuant to the Freedom of Information Act request and ask for body cam footage, photographs, measurements, anything that the police or any agency of the police did. And that can be really helpful. If your insured took photographs, get those and save those. Time and time again, we talk to insureds that took photographs, but they're gone. They don't have them anymore. And those can be really helpful. So right away, ask your insured if they took photographs and make sure that you're saving them, because there's a good chance by the time the case is in litigation, that insured lost their phone, lost the photographs, didn't save them to the cloud, and they're gone. If any measurements were taken, make sure you document those as well and save those in addition. Sometimes to gather this initial documentation, it can be really helpful to get a private investigator on the case sooner rather than later. They can do things like conduct a scene canvass. And more, we're finding residences or businesses with cameras. Ring cameras, red light cameras, and those get recorded over pretty quickly. So if you get a private investigator out there right away to do a scene canvass and look to see if there are cameras or anyone who might have had a bird's eye view that could have witnessed it that didn't come forward and isn't on the police report, that can be really helpful as well.
And I would say also April brought up a good point about the fact that the technology a lot of times gets written over quickly, and so it's important to jump on it. I would say the same thing with anybody you talked to, whether it's even if, like, for example, if you're insured as a company and you have a company driver that was involved in the auto accident and you're talking to them and they've worked there for 15 years, and this is a day or two after the accident, most states have a 2-year statute of limitations. So they might not be working there in 2 years. So I would get as much background information as you can with them, their actual mailing address. Ask them, like if you can get, like a name or a phone number of a relative, just so that you're able to get in touch with them again. With witnesses, I would ask where they work. And additionally, witnesses are a little bit more hesitant to tell you what their mom's name is necessarily, but they might be willing to, depending on how the conversation goes. But also email addresses from everybody, personal email, and personal cell phone numbers, home phone numbers if they have that, just any information you're able to get, so that in 2 years or 3 years, if this is going to trial, you're able to find them whatever way you can. It's going to be really important because a lot of those people's cell phones change, their work changes. So whatever information you can have, that you can really get a hold of them.
Absolutely. All right, what's after the police report? The next most important thing to start looking at are emergency department records. If the claimant went to the ER, these records are really important. While the police report may not be admissible, typically in most jurisdictions, all statements made to ER professionals will be admissible in the civil trial. And typically when they've gone to the ER, they might not have lawyered up yet. So they might be a little bit more forthcoming on those records than you'll see in later medical records. ER records can sometimes contain some gold. So make sure you're requesting those and know what you're looking for. Was the, how did the claimant appear to the nurse, to the treating physician? What did the claimant report? I'm sure you all have seen situations where at the scene and to the ER or EMS, the claimant denied loss of consciousness, denied a head injury, but down the road, you're getting a traumatic brain injury claim. So make sure you're looking at the ER record to see what they actually told the treating physicians in terms of whether they lost consciousness, whether they hit their head, what exactly they're complaining of in terms of what pain they're feeling. Look to see what studies were done. Typically in hospitals, you're going to get x-rays or CTs. Also look for what was recommended. Were they kept overnight? Were they released later that day? And if they were recommended to follow up with a particular provider, did they do that? You'll often see situations where the emergency department record says to follow up with an orthopedist, but they end up seeing a chiropractor. You want to look into that and find out why they did that. Maybe they lawyered up and the lawyer recommended they go to a chiropractor instead, but look to see what the emergency record actually recommended and whether they followed through with that. Other medical records that you're going to look for are treatment thereafter. These, records that we're talking about here are whether or not the plaintiff went for just a one-time evaluation or established a relationship with the doctor, and therefore it truly is a treating physician. This is a significant issue we see pretty often in Florida because the plaintiff's bar has a pretty big network with a lot of the doctors, and there's a lot of patient referral going on in our state. I know that occurs in other states as well. When you see those particular doctors, you can kind of guess what treatment or what surgery they're going to recommend. And you can kind of tell as you're reading the record, well, it looks like the claimant found an attorney. You see the records where the claimant's treating with a chiropractor, doing great, seems like the injury resolved, then all of a sudden they're going to a pain management specialist. Well, they probably saw an attorney that referred them to the pain management physician in network. Some jurisdictions allow you to explore that attorney relationship with the doctors and some don't. As of right now in Florida, we're not permitted to inquire whether the plaintiff was referred to a doctor by his or her attorney, whether it was a one-time referral or whether it was an extensive treating doctor. But we're hoping that changes. There's actually a bill that we expect to pass in the near future that would amend Florida statutes to allow you to question plaintiffs regarding such referrals. And so make sure you know in your jurisdiction whether or not this is someone that was referred by the attorney, and if you can inquire more about that, because that certainly helps you in terms of evaluating, knowing how a jury is going to perceive that treatment in those records. Look to see how the complaints and the treatment are evolving. As I mentioned before, they're going to a chiropractor, everything's going great, and then all of a sudden, pain management specialist comes and they need all of this future treatment. Are they really improving? Are they going to a chiropractor with, for a year and you see no actual improvement, but they're still going 2 times a week to get that treatment? Those are all sort of red flags and raise the question as to who's really suggesting that they go see the treatment. Is it really the attorney that's referring them? We're going to talk in a little bit later about experts, but one thing I wanted to mention that we are seeing more frequently is these life care plans, and this can be done by a treating physician. It can be done by an expert too, but it can also be done as a treating physician, and we're seeing these more in cases with minor or moderate injuries. It's allowing the plaintiff to put up a hard number in front of the jury in terms of future treatment. And you want to weigh those based on the picture of the claimant you have from the other medical records. Often we see a claimant that hasn't treated in years, but there's this life care plan, that's suggesting they're going to need this future medical treatment that's rather extensive. We look at those and we say, well, they haven't had treatment in 3 years. Why would they need, hundreds of $1,000s worth of future treatment? Well, unfortunately, they are able to put these in front of the jury, and sometimes the jury buys that, or even the jury, gives them a discount of that. But it's how they're getting these damages up, which is what we're here talking about today. How are they coming up with these damages, and what can we do to combat that? We have our first polling question for those of you who are earning CEUs. It'll pop up again. You are not being graded on how you answer it. Just please answer.
And while we're waiting for responses to the poll, I'm just going to share the second CLE code, which is SB. That's S as in Sam, B as in boy. And we're getting a lot of questions in the question and answer box and chat regarding CLE and CE. The CLE codes are just for attorneys who are seeking CLE credit. And you'll record those on the CLE form that was emailed to you yesterday. For CE, all you need to do is be on the PowerPoint presentation today, on this presentation today, and then respond to the 3 polling questions that will be coming, these that are happening right now. Thank you so much.
Well, thanks everyone. Great job with the polling questions. Even though you weren't graded, it looks like everyone did great. So thank you. All right, let's talk about billing next. There are several states, Florida is one of them, that allows for physicians to conduct treatment under letters of protection. So who's paying for the treatment? Is the law firm paying for the treatment? That's typically what's the case when we see a letter of protection. That means that the doctor is not going to get paid until there's a settlement or the lawsuit, and the attorney is essentially communicating directly with the provider regarding that. Typically, that means the bills are written up. And we are seeing more and more cases where the claimant has health insurance, but is treating under these letters of protection because it drives up the medical bills. The bill that we're hoping to pass that I mentioned earlier in Florida is also going to amend the statute pertaining to medical bills and will indicate that if a plaintiff has health insurance but treated under a letter of protection, they're only limited to offering evidence of the amount of the health that the health insurer would have been obligated to pay. Which is great and has not been the case going forward. So check your jurisdiction and see if medical treatment was done pursuant to letters of protection. What does that mean in terms of what can get boarded at trial? Because that can be fairly significant. That can change the damages. And so you want to make sure you know what the law is in your state. Many states allow plaintiffs to board their total medical bills regardless of what's been paid by insurance. The most common exception to that is Medicare. Typically for Medicare, only the Medicare lien is boardable, but any other insurance is not regarded the same, and so they get to board their entire total charged at trial. The only other exception I've seen sort of routinely is actually medical benefits through the military, TRICARE, because it's a federally funded program like Medicare. So I had a recent trial in Gainesville where the medical bills were in excess of $1 million, but because the plaintiff was covered by TRICARE, the judge only allowed the lien amount, which meant they were under $400,000. And that was a big reduction. So the jury only heard about the total lien amount, which was significant in our case. So make sure you know what the jurisdiction says about what actually can and can be boarded at trial.
And that's, I think that's huge. I never heard of TRICARE until April had that trial. And but it significantly, from what April told me, reduced the amount that was actually being able to be boarded that the jury could see. And where I practice in California, they also have limitations, and we'll talk about that as to what can be boarded based on what was actually going to be paid, even though that the care was provided on liens and hasn't been paid yet. So it's but also in Illinois, the protections aren't as strong. So it really does depend on what's going to be boarded. What your past medical is very different in each jurisdiction. So again, that's something that's important to keep in mind, and or if there's Medicare, or if it was TRICARE or something like that. So these are the types of things it's important to drill into really early on.
And when you're talking settlement with the opposing counsel, you have to sort of compartmentalize a little bit, because what can be boarded isn't necessarily what has to get paid back, right? So for settlement purposes, you might know that they have to pay back a certain amount, even though they can board their full medical expenses at trial, and they'll come back at you and say, well, we get to board the full amount. Well, we know that, but we're talking settlement here. And in terms of settlement, we know that you only have to pay back a much smaller number than what actually gets boarded at trial. So you have to look at it a little differently. We know what you can board at trial, but we also know what you have to pay back here, and it's not the same number.
So I'm going to start with some of the external considerations when you're having a claim. April went into great detail about sort of the things traditionally that one would look at with a little bit more depth as to some of the challenges and things to like look at, like for example, TRICARE and Medicare. But these are the external things to the claim that I think sometimes get missed. And one thing I would caution everybody in the insurance industry to think about when you get a new claim in is just to make sure you know your policy. I know there are certain people that have dedicated desks and they're really working on the same insured or the same couple of insureds every day, and that's great. But for those that get new insureds on a regular basis and the policy might be a little different, just make sure you're aware of what that policy is. And is it a personal lines? Is it commercial lines? What are the limits? What are the exclusions? Not because I'm saying that you should come up with a coverage opinion, but just so you're aware of what is actually in the policy, and because that's sort of that is definitely the framework of what you're going to be analyzing. Also, this is something that is frequently missed: is there other insurance available? And April gave the example of the slip and fall at Disneyland. Now, so who is the plaintiff gonna if there's a slip and fall? Who is the plaintiff gonna sue? Obviously, because they probably don't know how wherever they are is organized. So let's say it's even an office building. They're gonna sue the landlord probably of the office building if they fall in the front entranceway, and maybe if they know that it's managed by one of the commercial management companies, which are usually sort of listed in the beginning of the building somewhere, they might sue them. But there may be 3 or 4 other vendors that are involved in the floor care at that office building that are not readily obvious to anybody walking into that building. For example, I had a case once where the not it wasn't just the office building had a landlord. It had the building itself was entirely rented. There was a management company. There was a security company that was supposed to be watching out for hazards, which include water on the floor. There was a floor management company, and they even had a separate company that would come out during rainy or snowy seasons and put down mats. So all of these different companies are potential plaintiff or defendants in that case. They also might be companies that named that your insured has chosen to shift their risk to through a contract or through an additional insured status. So for example, in that case, the company that was responsible for the floor care and the company that was responsible for the security had executed a contract with my client, the insured, who was the landlord actually, and said that we will indemnify and defend you for any claims that arise from the work that we do. And we'll also name you as an additional insured on our general liability insurance policy. So there were 2 companies there that were potentially on the hook for the defense and indemnity of the insured that I was representing. So that is think about that. That's amazing. You think, okay, if they pick up those tenders, if we end up tendering the defense to them and they pick it up, they accept the tender of defense and indemnity, that means that your insurance company, the insurance company for the landlord, no longer has to be responsible for the defense fees or any indemnification payments, whether it's a trial or it's settlement. So it's something to keep in mind if there's a potentially other insurance available that you can shift that risk to, because they've already paid for it. That company paid to, as part of their contract, to shift the risk. So it's important to keep that in mind if there's something there. And it's an important thing. It's not probably going to be readily available in your initial notes, but it is something to talk to the insured about and say, hey, who does your floor care? Who's responsible for this? Is there another party available that was supposed to be taking on these duties? The insureds a lot of times won't volunteer that because they're not thinking that way either. But it's an important and it's a key way to shift the risk. There's also jurisdictional considerations, and some of them we're pretty aware of, like statute of limitations, but also no fault states. I've done a lot of work in New York, which is a no fault state, and April is in Florida, which I didn't even know was a no fault state. But and it's important to make sure, is it, if it's an auto case, are you in a no fault state for this accident, and is the no fault triggered by it? Also, how quickly the complaint moves from, or the case moves from the complaint to trial. Um, and then other weird jurisdictional issues, such as joint and several liability. I'll tell you that joint and several liability is pretty standard in Illinois, but in Indiana it's just several only. So it's Indiana is a much better place to be a defendant in a personal injury case when you have multiple defendants than in Illinois. April, were there any other thoughts about sort of jurisdictional considerations you've seen from comparison from the different states you've tried cases in?
Yeah, joint and several is one that's interesting. It comes up with a lot of vicarious liability cases as well. Florida does not have joint and several liability except for some certain limited circumstances, which interestingly, we have a Florida statute that did away with joint and several liability, but then, Florida case law kind of brought it back in some respects. So you need to look at that too. You might have a state that says, oh, there's no joint and several liability, but actually there's a couple exceptions to that could end up applying. So, double check, because that can, that can be a significant impact on the case as to whether or not you could end up paying for the entire thing. The other thing that we have in Florida, some additional jurisdictional considerations that are a little different for us, is that we get because plaintiffs' attorneys are in network with the doctors. We see a lot of cases where surgery is done quicker than it should be, or maybe it shouldn't have been done at all. Plaintiffs that are rushing to surgery because of that. Well, we unfortunately in Florida have a Florida Supreme Court case called Stewart v. Hertz that says that if there is any subsequent medical malpractice, the initial tortfeasor is responsible for that. So if I have a situation where my insured caused an accident, the plaintiff got surgery for that accident, and it made him or her worse, I'm on the hook for that. And actually, if I even try and argue that there was subsequent medical malpractice, I get a terrible jury instruction that comes in and that I don't want to come in. So, know whether or not you have a jurisdiction that has that as well, because that can really, tailor how you're operating in terms of the case. Your experts, you want to gear them in those kind of situations to say the surgery wasn't reasonable or necessary, but I don't want you to say it was committing malpractice to have the surgery performed. It's walking a fine line there.
And then one of the other external considerations, and April touched on this, is whether the medical bills have been paid or if they are on a lien. And the most, or a lot, I would say maybe it's half and half now, though I haven't looked into it, of the states have sort of limited exactly what April was talking about, where the plaintiff's attorney sends the plaintiff to their chosen medical providers, and the bills come in at 3, 4, 5 times what the health insurance would have paid. And what the person, if they had just called up and said, I'd like to have my surgery on my elbow, that would have been even less expensive than what it appears on these bills a lot of times. So most states, or half the states about, have instituted some check on that. And again, it's not a slam dunk either way. I can tell you in California, it's motion practice at trial a lot of times as to what's really the actual past medical amount, and you end up having experts, but you generally are able to drive it down a fair amount. And in a case where we're talking about the difference between 600,000 in past medical going down to 150 or 200, those experts are worth it. So the important takeaway is to make sure you know what the rule is in the state that you are dealing with at that time, and also going back to what April said, who's actually paying the bills. Every once in a while, you'll see a claimant where they have health insurance, probably through their employer, and they send all those bills through. Well, that's probably not an issue, because those are the health insurance negotiated rate, and that's what is boardable, and that's not an issue. But when you start seeing all these bills going to the law firm of so-and-so, you think, okay, it's something to look into. Also, one of the other external considerations that we talk about as lawyers all the time is, where is the case? And I will tell you that this is an actual organization that does this every year, and they've been doing it for like 30 years, what they call judicial hellholes. These are the court systems where if you're the defendant, you're at a disadvantage for many reasons. And it's interesting when you look at them. I mean, I practice, and April practices in Cook County. I practice in California. We've both had cases in New York. You can see why. It's a combination of the juries, as well as the way that the court system is structured, the way that trials generally run, and juries are chosen, and we'll talk about that in a few. But it's important to think about that, because again, a case that's pending in New York, and especially the number one what's been termed judicial hellhole in New York is the Bronx. That person who, like, let's say has a fusion surgery, and they're 35 years old, the value of that case is going to be very different than it would be in Indianapolis, or somewhere that is not one of the judicial hellholes. And generally, the juries are a little bit considered a little bit more conservative and a little bit more reasonable. So it's an important thing to keep in mind when you're evaluating a case and setting reserves. That's an external consideration that it's more of an art than a science. And I wanted to ask April to talk a little bit about lost wages, because she's truly an expert on this from her trials, and the ability, sort of analyzing and driving them down and attacking them. And I think this is one area that I think lawyers and claims professionals have issues or challenges addressing.
Yeah, lost wages is one of those economic or compensatory damages that can be a little trickier than medical bills, because it's often not as easy to prove. We've got two components of it: past lost wages, or what we call future wages, or future loss of earning capacity. And you've got situations where some claimants will just allege past lost wages. I missed 2 weeks from work because of my injuries. It's a little easier to quantify, right? Or some claimants that are alleging future loss of earning capacity because they feel as they get older, they will have less of ability to work due to their injuries. And then, of course, we've got some claimants that allege it all. More and more, we are seeing plaintiffs' attorneys dropping the wage claims before trial, because, first of all, they don't go over well with juries unless it's a significant case and unless they can really prove it. And they are a little more difficult for plaintiffs to prove, and they're expensive. At least the future loss of earning capacity claims are expensive, because typically you need an expert. Past lost wages are a little easier if the claimant filed tax returns and worked steady jobs. You can typically, see the numbers pretty easily. Oftentimes, I will let you know that wage claims are pled in the complaint, but then when they respond to discovery, or when you take their deposition, they deny a wage claim. I would suggest, if that happens, tell your defense counsel, move to strike the wage claim from the complaint. That way, you're not blindsided with a late wage claim. And they'll say, well, I pled it. So now you've foregone all the discovery pertaining to wages because they told you at deposition that they weren't going to allege one. When they do that, move to strike it from the complaint. That way it's off the table. But if they don't, if they continue to plead a wage claim, you've got to work hard to gather all the information that you can to look to see if there really is a valid wage claim. Again, tax returns are a great way to find out whether or not there's a valid wage claim. Subpoenas to every and all employer you can find under the sun. That sometimes is difficult because you have claimants that say, I don't remember who my employers were. Get as much as you can, obviously, from the plaintiff, him or herself. Also, even if they say they've never made a workers' compensation claim, pull those workers' compensation records. Sometimes those contain information regarding employers that they forgot about, and you can pull those records too. Almost always, for future loss of earning capacity, it just requires an expert. We see a fairly decent amount of wage claims where the plaintiff had a minimal education, a very physical job, and now, because of their injuries, can only do sedentary or light work, but they essentially don't have the educational history or the training to do sedentary to light work. I would recommend getting your own expert to evaluate sooner rather than later if there is a real potential lost wage claim, because they can assist you not just in terms of responding to plaintiff's expert, but even helping you question the claimant or plaintiff at their deposition to start gathering that information sooner rather than later. They have a real wage claim. What should I be asking for? What would you need from me to support and show that they don't have a valid wage claims? We often see these wage claims that are based on speculative earnings. So the more you can gather information and show that there actually is no valid wage claim, that the earlier on in the case, the better off you're going to be. What does your policy say about it too? Here's what we mean by that. Each carrier might require something different. Remember, we're talking about reserving settlement negotiations in addition to trial down the road. But what does your carrier say with respect to what evidence is necessary in order to set a reserve that includes a wage component? Because as we mentioned, often there's a wage claim, but you look at the tax returns and there's no appreciable difference on there. Or they tell you they missed time from work, but their vacation time covered it. So they actually didn't earn any wages. So find out what your carrier requires in terms of evidence for that wage component so that you can make sure you're asking your defense counsel for it. And sometimes if you have situations like that, you can come to an agreement where you're looking at some kind of middle ground there or something in the middle in order to evaluate it at least early on for purposes while you're still gathering that information. We've got our next polling question that's going to pop up for you. Again, not being graded on accuracy, just answer it for us.
I'm going to leave that poll open a few more seconds. I know last time people said I closed it too quickly, so I'm going to leave it open for a little bit more because people need that for credit. Okay, I'll give you about 5 more seconds.
And if it closed too early, just put it, send us a question and answer, so we'll give you credit. Sorry about that. Excellent. Well, thank you. Oops. Go back. So I want to. We're getting close on time, and there's a fair amount of material we wanted to go through. But one thing evolving evaluation after the suit is filed is important, especially for reserving. And I know nobody likes to touch a reserve and justify why the reserve has changed, but it's an important thing to do. It happens with liability, and it happens through deposition testimony and experts. Generally, the reserve is set early on, maybe in the first 90 days. And the deposition may not go until the next, we might be a year and a half into the case, depending on where the case is, before that plaintiff's deposition goes. So I would just caution everybody with liability. You get a report from your defense attorney. Ask, does this change the evaluation of the case for money purposes? However you'd like to phrase that, as far as liability goes. And so, because that's an important consideration, did we think that it was a 50-50 liability, and now we've done the plaintiff and the defendant's deposition, and it really looks like our insured caused the accident for doing motor vehicles. It's important to address that when we have that information. Nobody has a crystal ball, so it's important to keep that in mind. And I would recommend asking the defense attorney, does this really change this? Because I was thinking it was 50-50. Is it not 50-50 anymore? With respect to damages, this is always evolving, always. And a lot of times, for example, we'll set a reserve 90 days in. We do the deposition within the first 9 months, let's say, And then we find out that the plaintiff has had additional surgeries that they're claiming are related to the accident. And we're not looking to the trial from probably 2.5 years in a lot of jurisdictions from the time the complaint is filed. So it's important to make sure that whether it's the plaintiff's deposition or medical records or experts, that we're continuing to evaluate what the case is worth with damages based on the damages and how they evolve. April, did you have some thoughts about that one from your trial experience?
You know, the one thing that stood out for me in this one is I mentioned a little bit earlier talking about future medicals and life care plans. So I talked about it a little bit earlier, but I know we are seeing that all across the board. And I think I even saw a question and answer about that because we're seeing them everywhere. They're coming to us sooner rather than later. And I will tell you that they are having a big impact on juries. Juries like to hang their hats on reports and numbers and doctors. And so experts, are really, significant. And when the plaintiff has an expert that talks about future medical care, it gives the jury something to hold on to. I had a recent trial where we had a great result in every respect, liability and damages. But the one thing that had my head scratching was there was a life care plan that was about $5 million. Plaintiff hadn't had treatment in 2 years and said definitively on the stand he didn't intend to have most of the treatment on there. Still flabbergasted, the jury gave him the entire life care plan. So, they're really, that's why they're being used like that because juries they're seeing numbers boarded up there and they're going with them. So that's what I've seen to be the most significant impact on recent trials are those life care plans. Unfortunately, we attack them as best we can by saying the plaintiff hasn't had the treatment. Ask the plaintiff. Plaintiff says he's not intending to have the treatment, but they're still getting awarded, unfortunately.
And life care plans, I think, are if you have a case where you have a life care plan, and as April said, we're getting them in smaller cases. They used to sort of be reserved for the cases where we're really talking 7 figures. But we're seeing them in smaller cases. And they're a wonderful tool for the plaintiff's bar because it lays everything out very clearly. It's saying that this person is going to need this medication and they are going to have to take 1 tablet every day going forward for the next 43 years. And they lay it all out how that works. And it's almost when you read, for those of you that haven't looked at a life care plan, it's a lot of almost sort of like very nicely formatted Excel spreadsheets listing the treatment or the modality or whatever it is that they're saying that the person is going to need going forward, and then setting it out for the rest of their life. So it's very easy for a jury to look at and be like, and it's easy to put it on a board. So it's very important if you get one to jump on that and talk to your defense counsel. How are you going to attack this? What are we going to do? Because it's dangerous like that, because it's very easy. They're very easy numbers for somebody to be like, well, I see that. If they're going to have to take that medication or they're going to need 4 more surgeries, this is what it costs. Okay, I get that. The other thing that I feel that is very vital for us as defense attorneys when we're evaluating what a claim is in a case is going to be worth at trial and for settlement purposes are the jury instructions. The jury instructions are so different in every state and what they're actually instructing the jury on and what the actual verdict form even looks like. And April, you had a great example from Florida that we were talking about the other day.
Yeah, I mean, it's important to pull the key ones early on in the case. If you could authorize your defense counsel to do that, key ones on liability and damages, that can really help you understand and evaluate your jurisdiction. In Florida, there's a jury instruction that basically tells the jury that an aggravation of a pre-existing condition bears the same weight as a new injury. So often we get these cases where, this is a pre-existing condition. Plaintiff already had a ton of neck and back treatment. Well, guess what? An aggravation of that is almost the same as is treated the same as a new injury in Florida. So you need to know that up front. That way you can analyze it for purposes of settlement and also help with your experts in terms of what we're looking at here. We need to not just say this is not a new injury, but we also need you to be able to tell us that this is not an aggravation of a pre-existing condition either.
And then also one of the other things that we see a lot and we think about and we talk about at a law firm is those trial considerations that are usually down the road. And I'll tell you, like, for example, in Cook County, Illinois, which is one of the judicial hellholes, and Los Angeles, where I practice a lot, you don't know who your trial judge is going to be until the day of trial. And it could be a number of people, probably like in excess of 30 people to choose from, depending on the day. But then April was saying that in Florida, most of the time you have that trial judge when the case is filed.
Correct. Yeah, our judge stays with us for the most part unless they're transferred to a different division up until trial. It's post-pandemic changes sometimes, only if the judge gets really backlogged and pulls in a senior judge, but typically that's your judge for life.
And that's a huge consideration. Is that judge going to be somebody that you're going to want to have at trial? Does that judge are they pro plaintiff, and you think that's going to be terrible at trial, and you're unable at that point to get rid of them? Same though with, like in Cook County, in Los Angeles, we're surprised the day of trial. Well, we didn't know we were going to have this person, and you get one change in most jurisdictions. You do in both of them, but it's hard to say, what that's going to have a huge impact on what that case is worth and how that trial is going to go. Also, where does the jury come from? I will tell you that the way that the jury pool for Cook County, Illinois is huge. It's the entire city of Chicago and most of the suburbs for about 20 miles north, south, and west. And so it's a very the jury is a lot of different people, and they come from a lot of different backgrounds. Other places aren't like that. In Indiana, you'll have very, very small counties that's who your jury is going to come from. So that's a really important thing. Also, what's the size of the jury? In April, you're saying that Florida is a 6-person jury, correct?
Correct.
Yeah, and Cook County is still a 12-person jury, and in Cook County and Florida, it does need to be unanimous. So, and in other places it doesn't. So, those are important things to think about. They're not always the most important thing with setting the reserves that first 90 days, but it is something that's very key to sort of analyzing the case. And with that, we get to our third polling question.
Oops, I'll leave it open for a couple seconds longer. Make sure you get your answer in.
And I'm going to chime in with the third and final CLE code, which is 25. Again, 25. Thank you.
And since we're getting close to the end, I don't think we're going to have time for questions, but if people, we do have the Q&A, and we're going to try to get those. We're going to send everybody a copy of the presentation that attended, and we're going to we'll try to answer your questions that way, but feel free to reach out to me or April. Our emails will be on the email that you receive at the end of the presentation. We're happy to answer any of your questions, and we're also always happy if somebody's looking for counsel in any of the states where we practice. We're always happy to meet new clients. So please feel free to reach out to us. And with that, hold on. There's just a couple things that we wanted to go over with verdicts and settlements and analyzing for settlements. And one thing that both of us really like as a tool, but cannot be over used too much, and sometimes it is used too much, is jury verdicts and jury verdict reports. And and I think they're a great tool, but I also think that they've changed a lot. And April and I were talking about sort of how we analyze them differently after COVID, right?
Yeah, I mean, it seems like post-pandemic jury verdicts are just very different than they were pre-pandemic. Pre-pandemic, you saw pain and suffering damages tied to economic damages, and that just doesn't seem to be the case any longer. There are some states, Florida is one of them, that allows a per diem argument, and plaintiffs' counsels are making those arguments. What that means is plaintiff is entitled to $10 an hour for every waking hour for pain and suffering. If you've got a young plaintiff, that adds up pretty quickly. So that's why we're seeing those pain and suffering verdicts be more significant. And that seems to be a trend coming out of the pandemic that we didn't see before.
Yeah, and I will tell you, mediators and trial judges that I've been in front of have said they're shocked with the size of verdicts that they are seeing in cases that have been tried in the last 2 years after the pandemic. So it's something to really consider. So if you're looking at jury verdicts reports that are a year or two, like for 2019, it doesn't seem like that's that long ago, but the world has really changed. So keep that in mind. The other thing is that again, we were talking about in the beginning, April talked about the social media and the great things you can find from that, is who is that plaintiff that is actually going to be in front of the jury, and who is that jury? Is that person, based on who they are, all of their background, um, are they going to be well perceived by that jury? Are they going to play well in front of that jury? Or is that jury, are they going to love them, or are they not going to like them? And there's a lot of different considerations with that, and we could probably spend a whole day talking about the different ways that could play out. But the keep that in mind when you're analyzing the value of a case. And also, how close are the verdicts, the reported verdicts and settlements that you're looking at, to the case you have? Is that plaintiff similar injuries, but is the plaintiff really very different in, age-wise or what have you? So it's something to keep in mind. And I know we're a couple minutes over. I'm going to skip over the mediation, but with releases, this is something that April and I see issues with all the time. I'm always so happy when I hear from my friends working in insurance, when they're able to settle cases and it didn't go into suit. But when you are able to settle those cases, make sure that the release is airtight and ironclad, because make sure that you are releasing the right parties, and that everything is being considered in the release. If it's a commercial lines case, and it's like, for example, you have a car accident with a driver driving a commercial vehicle, make sure you get all of the names, the driver's name, all of the company names on that release that you possibly can, because this is where I've seen issues arise. And I will tell you, in places like Florida or California or Cook County, where you have some judges that are fairly pro plaintiff, and there's been a settlement with an unrepresented party, they will allow, and then that party finds a lawyer, they'll allow some loophole. Oh, well, we didn't realize we were releasing the company that employed the driver also. So make sure that you're doing everything you possibly can to make those releases as ironclad as possible.
And I would also caution to be consistent. The plaintiff's bar talks. So if you agree to leave out a material term with one attorney, chances are, someone else in the plaintiff's bar is going to find out about that. So if there are material terms that are important to your insured, stand your ground as best as you can and try and be consistent, because in most jurisdictions, the plaintiff's bar does a good job of communicating.
And I would say also, like with releases, if there's something that seems like the person's difficult, it's a represented party and the lawyer's being difficult, and it seems like there's something else going on, reach out to your defense attorney, reach out to April or I, reach out to your staff legal if you have it, because releases are one of the areas. I probably in my career have had 5 or 6 cases where the case came back after it was settled by the insurance company pre-suit, because there was an issue with the release, and it wasn't anybody being lazy or sloppy. It really was, there were tricks being played, and it really ended up being a disadvantage to the insurance company. So keep that in mind. And with that, please send us your questions. I know we're over, and I appreciate everybody staying for 5 extra minutes. I know we're probably cutting into your lunch, but thank you so much. And feel free to email us or contact us, and you'll be getting a copy of the presentation via email. But we are here, and I hope to see a lot of you in New Orleans.
Thank you very much, everyone. And I just quickly, because I saw the question come up and it's something I'm very excited about, the Florida Tort Reform Bill is expected to pass and the statute would go into effect July of 2023. So cross your fingers.
Yeah, that's excellent. Thank you, everyone. Have a great rest of your day.